Representative Staffman, would you like to open on your bill?
Yes, thank you, Mr. Chair. Thank you, members of the committee. I bring you today House Bill 552, which is titled the Montana Racial Justice Act of 2021. I want to begin by thanking my co-sponsors, Representative Hawks, Windy Boy, Weathermax, Pergeroy, Whitman Pena, and Smith, who collectively constitute the Native American Caucus from the House, anyway. So this, I'm Ed Staffman. I represent House District 62, which is the historic district and downtown district of Bozeman, stretching to the Gallatin Range. So the heart of this bill can be found in Section 4, right in the center of the bill, of course. And that sentence says, the state may not seek or obtain a criminal conviction or seek, obtain, or impose a sentence on the basis of race, ethnicity, or national origin. A violation is established if the defendant proves, and it goes on. So that's, I hope, a proposition on which we can all agree. And so the rest of the bill identifies some of the problems that stand in the way of that goal and some of the solutions. So the whereas clauses identify some of the problems. It sets out the notion that our courts have at least articulated that race discrimination is not is a problem and it needs to be remedied. But then there's some specific areas where it tends to show up and where it's not remedied. So one case, for example, involved a case where the defendant's own attorney harbored racial animus towards him and his racial group, and yet there was nothing that he could do on appeal. I cite a case called Peak v. State, which is on page 2 on the top. I happen to know that case well because it was a case that I represented Mr. Peak. And that was a case where the trial judge referred to Mr. Peak's family as the N-word from Tennessee. And on appeal, the court said, well, that's offensive, it shouldn't have been said, but it didn't so infect the proceedings so as to result, so that you can get a result, although the court did reverse on other grounds. In Montana, the law is, and I quote from the case of State v. Haithcox, it is not enough that the prosecutor's remarks are undesirable or even universally condemned. Rather, the question is whether the comments so infected the trial with unfairness as to make the resulting conviction a denial of due process. So it's a very, very high standard. And in other areas where race discrimination is alleged or shown, unless you can show that it was purposeful and intentional, there's no remedy. One of the more common areas is jury selection, where a defendant might allege that a juror has been struck because of his race. And so long as the prosecutor has a reason, the prosecutor would say, well, I don't like people with bolo ties or who have blonde hair. Unless the reason is racially discriminatory, there's no remedy. So what does this bill do then to address those kind of problems? First, it sets out the legislative intent in Section 3, which says to eliminate racial and ethnic bias from the state's criminal justice system. And it says not to punish any kind of bias, but to remedy the harm that's been done to the defendant's case. And then Section 4, which I mentioned at the start, has a number of particular areas that it covers. So if the judge or an attorney or a law enforcement officer were to exhibit bias or animus, most commonly by language, there would be a remedy for that. If it's shown that race, ethnicity, or national origin are a factor in the choosing of the jury, there is a remedy for that. And then finally, on page 6, paragraphs 4 and 5 of Section 4, if the defendant can show that he was charged or convicted of a more serious offense than defendants of other races, ethnicities, or national origins who commit the same or similar offenses, there is a remedy for that. And in Section 5, the same thing applies to sentences. And what's really significant is the proof can be shown by statistics. So if you were to show that a particular judge or a particular prosecutor were to had 10 defendants and 5 of them were of one race and 5 of another, and the 5 of the one race consistently got a higher sentence, and that couldn't be explained, then that would be evidence of that would potentially get a remedy. The rest of the bill is a bit, it describes the proceedings for how to go about this remedy, either in the trial court, or if it's happened and you discover it later, you can go back on a habeas corpus petition to raise the issue. So that's an overview of the bill. I think it's an important bill. There's a few other states that have enacted similar legislation. Indeed, I copied from some of those. I think it's nothing more important. I called this the Racial Justice Act, but I could have just as well called it the Judicial Integrity Act of 2021. It's something we all agree on, but very often there's no remedy for in existing law. So with that, I'll step aside and hear from the witnesses. Thank you, Mr. Chair, members of the committee, for this good hearing. There were a number of witnesses I'd hoped would be here, but this they couldn't manage to get in the time. I hope that the one witness who had the picture and couldn't get it off can submit her testimony, because she's involved in collecting data on this kind of thing, as well as part of an organization that does that same thing. Some of those people simply couldn't be here on such short notice. There's not much I have to say in addition to what we've already talked about. I do want to mention that in the state of Washington, the Supreme Court recently issued a statement directed at the lawyers in the state and the judges. And it was signed by the entire Supreme Court of Washington, which consists of people from different sides of the aisle. And it said, I'm just going to read you a portion of it. Too often in the legal profession, we feel bound by tradition and the way things have, quote, always been. We must remember that even the most venerable precedent must be struck down when it is incorrect and harmful. The systemic oppression of Black Americans is not merely incorrect and harmful, it is shameful and deadly. It is only by carefully reflecting on our actions, taking individual responsibility for them, and constantly striving for better that we can address the shameful legacy we inherit. We call on every member of our legal community to reflect on this moment and ask ourselves how we may work together to eradicate racism. And it goes on, but that's the spirit with which I bring this bill. There may be a few bad people out there, but they're very few. It's a systemic problem, and it'll never go away unless we're willing to honestly confront it. Now, some of you may believe this is not a problem, and that's okay. If you don't agree, I'm thinking of the bill we passed yesterday on integrity of our election. There'd never been a case, as I recall the hearing, where there'd been any case of election fraud or anything like this, but the argument was made that the integrity of elections is so important that we should pass a bill protecting that integrity, even if there's been no problem. And we've seen it in the sanctuary city bill, for example, where there are no sanctuary cities, but the committee felt that if there would be one, that would be so harmful that we should act anyway and prevent it. I think that same standard needs to be applied to racism in our criminal justice system, whether it's overt or subtle. That even, you don't have to agree with some of the witnesses that there is a problem, but even if there's not, we should make sure there's a remedy for that case where there will be one. And that's the spirit of this bill. I think it's a good bill. We're not the first state that would be enacting it. And I urge a due pass. Thank you.